is that our legal system isn't cranked up so as people can get equal access to the law.
Probably we'd say, yes, sir, and that's why everybody's here.
That's a really big problem. All too often, the people who get the best justice under our legal system are the people who can get into the system in the first place. But all too often, it costs us too much. And that's a really, really big problem. That's why we've got legal aid. But legal aid is a really good thing. However, the reality is that there's not enough money in legal aid to go around. There's not enough money in legal aid to go around, and that's a really bad defect in our system.
All right, there's a gentleman there who's been waving his arms around strenuously, and if you'd introduce yourself.
So first of all, I'd like to say thank you for coming out and listening to us. Anyway, my name's Robert. The question I have is, do you think the use of legalese in the courts is a gatekeeper to the average people and acts as a buffer really to keep the average Australian out? Yeah. Also, I come across in some of my readings the term demure, and I was going to bring this up with Darryl, rather than putting a no plea in, that there is a term out there that can be used rather than put you're innocent as a demure, meaning to prove the contract that you're trying to place me under. Is that correct? So just a question.
I say to my students that if you're going to be a really good lawyer, you've got to be able to write really clearly. Because unless your arguments are really, really clear, they're not going to get up. Now, I know that many lawyers resort to complicated language. And sometimes that reflects the fact that they're not confident enough to be clear, so they try and obfuscate it. But you'll find that the really fine advocates, Robert Richters of the world, the really fine advocates speak as clear as a bell, and that's the way in which I try and teach my students. Because if you send your students out to practice law and they go to one of the major firms and the major firm can't understand what they're writing, they're not going to get very far. But they're not going to get very far in the profession either, because it's the people who have the most clear, logical, thoughtful minds that are going to be the best ones.
David. Sorry, just clarify the second question I had.
Oh, sorry.
Sorry,
Demurrer is a technical term, and I don't think it applies in the plea no plea situation. But it can apply in a contractual situation, and I'll leave the answer there because it's a little bit complicated. But I'm happy to talk to you after about that.
All right, David Woods has got.
Sir, my name's David. With your extensive knowledge, and I'm so happy that you are here and you're listening to all of us, it's great. Your extensive knowledge of our Constitution, the federal one.
Yeah.
I was told very recently that there's the British Colony of Australia Constitution Act 1900, and that's the way it was meant to be until it was changed, but that's not the real issue. The only thing I want to know is, with your extensive experience, how do we change the Commonwealth Constitution? Then I'll go to the second question about the state of Victoria.
The only way you can change the Constitution is by referendum.
Yeah. Does that also apply to any state or territory?
No, it doesn't.
Can you tell me why?
Because the constitutions of the state don't have the same standing as the Commonwealth Constitution. The constitutions of the state are just an ordinary act of parliament. Okay? They're an ordinary act of parliament. So the Victorian Parliament can change the Victorian Constitution to say one thing tomorrow, And then in a year's time, a new parliament can come back and change that constitution. You don't have to have any referendum. It's just an ordinary act of the parliament. But that's not the case with the Commonwealth Constitution. The only way you can change the Commonwealth Constitution, and this is why it's the most important document
Up to Parliament.
This is why it's the most important document in the country. You can change the Commonwealth Constitution only by referendum, and what that means is that you have to have a majority of Australians supporting the change and a majority of the states.
How do you explain the Australia Act then, sir? How do you explain the Australia Act?
This group has had a problem with the Australia Act right from the beginning because it has two things in it.
Yeah.
One, it purports to grant state sovereignty, purports to, which would repeal the Australian Constitution and take us back to square one, and then it purports to continue both the Australian Constitution in Section 5 and the Australian Courts Act 1828 in Section 11. These are the things that we would love some sort of clarification on. How can you have two inconsistent ideas in a single act of the Parliament? And that's one of the problems this group's been wrestling with.
And we went to a referendum on it in 1984 also.
Not on the provisions of the Australia.
Yes. Yes.
Yeah.
We'll follow it up actually.
Yeah, get it up.
What do you want, the Australia Act?
No, yeah,
I don't understand that.
Pretty point there.
Yes, I can say that.
haven't heard anything. The second question. An act to enable the Commonwealth and states voluntarily to refer powers to each other.
Yeah.
So there was an interchange of powers, comparing the states to be equal to that of the Commonwealth. And I've got to know, barely 47.6% of Australia said yes, which was not enough to carry. But my interpretation, and others, Peter included, read that. And then we looked at the Australia Act bill proposed by the federal government in 1985 and the content of the Australia Act, we saw question 2.
You need to see the writ. You won't see that on the stop.
Explain your argument to me over tea, and then I'll come back and answer.
Right, we normally break at about 8:30 for tea and Vicky's, but tonight I think we'll carry on till 9 o'clock and then break, if everyone's in agreement with that. This is a dull opportunity.
Shall we have a vote on that?
Oh yeah, look, would someone bring a glass of water, please?
Are you giving us an order? Is that Bill follows an order, doesn't
I'll hand over to Darryl. I'll go and get the bottle of water if they've got to get it.
Gentleman at the back has asked a question. Yes,
Yeah, Frank Colossimo is my name, and a couple of questions for the Professor. Number one, Supreme Court rules. I suppose they have an escape hatch by calling them rules instead of an act. Are they valid? That's my first question. And number two, I've been through 9 hearings at the supposed called Supreme Court, and I've been bastardised every time, particularly the last 2, where summary judgment was granted to a couple of justices that did the wrong thing from the beginning to the end and stopped me, prevented me from giving my account. Now I'm waiting on 2 weeks, or at least I've got 2 weeks left before the sheriff is released to come and take my property. So how do you find someone, when you're very low on funds, as was mentioned before, to try and win a case that is so fraudulently and so fraudulent and flawed from the beginning?
Yeah, I'm a lawyer. That means that I'm careful about the answers I give to people who talk to me about an individual case, because I just don't know enough about your case. So I've got no idea about what happened in the Supreme Court. But I'll take it as read that what you say is right. And if it's right, it puzzles me. If it's right, it puzzles me. Now, the first question you asked was, are the Supreme Court rules valid? Yes, they are. Supreme Court rules are valid as long as they are properly made by the court itself. The court has the power to do that. Okay, so that's straight up and down. There's no doubt about that. But the broader part of your question seems to be asking me, well, how come I didn't get a proper chance to make my case? I don't know the answer unless you tell me a little bit more about it.
Well, if you got a day or two, I'd be glad to take lots of time to play with.
Okay, look,
The only thing I'll say to you about that is that we now have implicit in the Australian Constitution a recognition of what the Americans call due process and what we call natural justice. Okay? A core component of natural justice is that a person has a right to be heard before the court. Okay? Now, if for some reason or another you're being prevented from presenting your case to the court, then that's a breach of the rules of natural justice, and you ought to go somewhere to get somebody to argue that.
this is one of the problems that this group is addressing, and one of the problems that we've discovered is that about 1952, the High Court was given power to make rules to make it an exclusive club. Now that appears to be a breach of Section 77I Constitution, and that particular issue has only ever been addressed, in my experience, by one High Court judge, that was Justice Mary Gordon, and she didn't go into it. But she was one of the 4 judges that gave the Australian people the cable principle. Now they're still working their way through that. Everyone admits there's a cable principle, but hardly anyone knows what it is, and perhaps the learned professor knows what the cable principle is.
Yes, I can. Normally, I give a lecture on the cable principle, and it goes for 2 hours.
I can understand this because I did 2 papers on the cable principle in uni when I went there. One I got 5 out of 35 for, and the second one I got a credit, and they were both the same.
Control beauty, wasn't it?
Anyway, we'll leave that.
In one sentence, the cable principle says that if a state court is what we call invested or given federal jurisdiction, then the state court has to act in a manner that's consistent with the proper exercise of Commonwealth judicial power. Okay? So same rules apply to the exercise of judicial power at state level as they do at Commonwealth level. Now, I'm sorry, that's very general, but you wanted a one-sentence answer.
Don't they always have to?
That's a pretty good one-sentence answer, actually. But the other thing that we sort of get out of the cable principle is that if you ask a judge to exercise federal jurisdiction, he has no choice but to do it. Anyway, look, Jim's been waving his arms around like a bandana big man.
We made a comment about most of the people don't know about the Constitution or the contents. So when it comes to the Supreme Court making court rules, which making, in other words, the court rules making a law for themselves, how do people know under the Constitution out of ignorance and deliberate attempt not to attempt the Constitution that those Supreme Court rules don't conflict with the Constitution, and they take advantage of that ignorance? So if they're making a rule which is a law, and they'll refer to that rule as such and such, but people don't know that. They don't know the Constitution, let alone the court rules. So what chance is there to have fair justice? Now, in relation to the question about the money, we're not denying natural justice because of the cost. Because we have a cartel where we're